Good morning. Good morning, good morning, good morning, everyone. Thank you so much for joining us. I apologize for a little bit of a late start. We were having technical difficulties, as you know. Anytime you need computers to behave, they never want to do so when it's time to behave. So thank you for your patience. And thank you for taking time out of your Wednesday morning to join us for this is actually our second VIP Listen and Learn, where we talk with uh, well-known experts in their field, and they share with us some of the lessons that they've learned, some of their expertise, give us some advice and some tips about how to do our business better and how to avoid some of the pitfalls of doing business. So this morning, we have my friend and esteemed colleague, attorney Corinne Koger. She is out of Philadelphia. She is a intellectual property attorney, and she has been invaluable to me as an entrepreneur. And so we decided to share her with you and share her expertise with you. And hopefully, if you have some sort of intellectual property that you need help with, or that you're thinking about, filing any sort of protection for that, you will find this webinar to be helpful. And what we're going to ask, she's going to give our presentation, and then we're going to follow up with a few minutes, about 15 or 20 minutes of Q&A. And we'll give you some instructions for that. But it would be great if you have questions, you can put them in the chat. Include your email address when you ask your question, just in case we don't get to your question. We'll be able to follow up with you. Attorney Koger will be able to follow up with you. So please be sure to include that when you ask your questions. So I'm not going to delay anymore. I'm going to turn things over to Ms. Koger and let her lead us for the rest of the morning. Ms. Koger.
Good morning, everyone. First of all, I want to thank Dr. Alexandra for having me here. I want to thank Tiffany for working with me to get this going. I want to thank Norfolk State and the Innovation Center. Before we get started, I have to give my obligatory attorney disclaimer. Please be advised that the information that you're going to receive today is for informational and educational purposes only, and that me presenting to you is not creating an attorney-client relationship. So we're going to start with the slides. So entrepreneurs, I'm so happy to meet with you today, especially because a majority of my business is working with entrepreneurs. Most of the times people, when they set off on their entrepreneurial pursuits, they know that they have to set up a business. They know that they have to set up their bank account, but intellectual property is an integral part of your business. Intellectual property helps protect your business. It helps protect your brand. And a part that I think that some people don't really realize is that it really helps you to scale up. So we are going to move on and get to, I'm going to tell you a little bit about me before we get started. I am the owner and founder of Koger Law Firm, LLC. I also have my own business, which is We Wear Our HBCUs. It is an apparel business. And I thought this is important to tell you because what I want to let you know is that I'm an entrepreneur myself. So I sit in the same shoes that you do. I go through all the same struggles and have all the same problems and hurdles that you do. So I wanted to combine my knowledge of the law, my knowledge of e-commerce, and my knowledge of intellectual property with you. I was born and raised outside of Philadelphia, PA, in Cheltenham Township. I graduated from Hampton University in 1999 as a mass media major. And then I pursued my legal career, or my law school career, at Howard University School of Law. So I think you can see a theme here. I am a huge HBCU supporter and have a company that caters to HBCUs. I started my legal career at the Public Defender's Office in criminal defense. And later I moved on to civil defense. So I was a trial attorney for approximately 16 years. So a majority of my cases were in the courtroom during litigation, conducting depositions and investigations. However, while I was doing this, I was still growing my business on the side, and decided that it was time to take a pivot out of litigation and to pursue what I love, which is intellectual property. I'm also a certified arbitrator in the state of New Jersey, which means that I hear cases before they go to court and try to help people come to a compromise. Just a little bit of background: I love outdoor sports, I love movies, I love memes, and I love Baby Yoda. So we're gonna move on. Okay, so again, this is my law firm, Cougar Law Firm LLC. What's very interesting is when I started my law firm, one of the things that I was promoting was I was a virtual law firm. And some people were like, "What is that?" And other people were like, "Well, why do you feel the need to tell people that?" Well, when I started, it was not normal for people to work virtually, and then COVID hit. So I'm glad that I already adopted to the new normal prior to COVID hitting. And now a virtual law firm is not foreign to most people. So my next business, the one I told you about, is We Wear Our HBCUs. It is an online store on Shopify where I do feature about 21 HBCUs, including Norfolk State. I did not forget about you guys. And I also feature different professions. So I have apparel for Black doctors and Black lawyers and women in STEM. So like I said, I just wanted to give you a background about me. Now, going forward, this is what we're going to cover today. We're going to cover an introduction to intellectual property. We're going to discuss what is a trademark, what is a copyright, what is a patent, and I'm going to take you through your own intellectual property inventory that you can do for yourself in order to figure out what type of intellectual property that you need. So we're going to move forward. And so, like I said, what is what? So a trademark is a word, a phrase, a symbol, or design that combines and identifies and distinguishes the source of goods. So most of the times when you think about businesses or brands, you're thinking about the mark that they use in commerce. And when I say in commerce, which is selling, that is what they have used to identify their business. A trademark is separate from a copyright. Quite simply, a copyright is an original artistic or literary work. So it is a poem, a novel, a story, even written music. And then a patent is for inventions. I'm going to actually get into the weeds of all these three different types of intellectual property as we go on. And we're actually going to skip this chart. And we'll probably come back to it later in the day. So what is a trademark? So trademarks are pretty much, like I said, you have a visual representation of what a mark is. I'm sure almost everybody can identify the marks that are listed on the screen, such as Coca-Cola, or FedEx, or Facebook. And these marks identify their companies. Next slide. And they fall under the governance of trademark law. We're going to move on a couple of slides. So there are a few different types of marks. There's a word mark and there's a design mark. So a word mark is exactly what it sounds like. It is the actual words. They are the words Coca-Cola without any design, without any color. A design mark is your actual logo. So one of the questions is, which one do I need? Do I need both? Which one do I get at one time? At what time? So moving on, I always suggest that people file for their word mark first. Again, it's just the words. In that way, you can use that mark. You can use that mark in any type of form that you want. After you achieve your word mark, which there's no guarantee that it will be granted to you, then you can apply for a design mark. a design mark are the visual representations. So what makes a mark trademarkable? So let's move on. Excuse me, guys. Let's see. Okay. When you are filing for a trademark, it is a very complex process. It's something that you can do for yourself, but you want marks that are distinguishable. You want marks that are ambiguous, and you want marks that are not merely descriptive. So how do you decide what type of mark you're going to get? So again, this is just base level trademarks, giving you guys an overview. Going forward in the slides, there is the United States Patent and Trademark Office. This is a website that is open to everybody, and you're able to go to this system to learn about trademarks and to research your mark. So in that second column where it says search marks, when you go down to how to use the trademark electronic search system, we're going to move on to the next slide. This is going to be the place that you search for where your mark, if your mark is already taken. Now, next slide. This is a lot, and I know it's a lot of small print, but when you file for your trademark, you're filing in certain classes. Class 25 is for apparel. Excuse me, I'm making my screen bigger. Class 41 is for education and consulting. And why is this important? Because you can have a mark that's similar to somebody else's, but if it's in a different class, the likelihood of confusion is not necessarily high, if that makes sense. So we're going to move on, and I'm going to give you some examples. So like I said, we have a word mark. So we're going to use Starbucks because it's pretty well known. Starbucks has filed for this mark, which is just the name, and they have the right to use this mark all across the country. Moving on. Here is the United States Patent and Trademark Office search that I just showed you. When you type in Starbucks and you look for all of the live marks, these are the marks that come up for Starbucks. This is just the first page, but there are 91 potential marks that could be under the Starbucks brand. Moving on. This is the Starbucks logo. So like I said, when you file for your mark, usually you want to get the word mark first, and then you go for your design mark. And the difference between the design mark is not just that it is an actual design or it's a graphic, it is that your mark is that complete design. So for instance, if Starbucks, or because Starbucks has filed for this mark in this green and white with a woman with a crown on, that is their design. And if somebody used it, and that design is not protected in a different color. So if somebody used that mark in red, it is not necessarily an infringement upon this mark. And again, that's very base level. And I'm going to show you how that plays out. Next. Then there's a combination of the marks. So this is the Starbucks design plus the words together, creating another logo for Starbucks. Moving on. There are also sound marks. These are some marks that people are not necessarily familiar with, but the ESPN sound, that has been trademarked. Next slide. I don't know if you guys are into Mr. Worldwide, but his signature sound has been trademarked. Moving on. Colors have been trademarked. If you look at this color, most often than not, you're going to think of the UPS man or the UPS van. And you can see in the slide, it's very descriptive as to what color is associated with UPS. Moving forward. You can also trademark smells. How many of you guys remember being a child and just knowing that Play-Doh smell? Well, that has been trademarked as well. So I wanted to go through these so that you can see that a trademark is not just merely your logo that's on your packaging. You want to protect yourself, you want to protect your business. And again, I can go deeper into trademarks and how you receive them. But one of the things that you want to do is protect yourself from infringement. You do not want anybody to confuse your mark or mistake your mark for a different brand. Conversely, another brand does not want you to have a mark that is confusing, that may cause a mistake or that may cause deception. Next slide. Okay, so I want to give you a couple of examples. So again, we're going back to the Starbucks mark. There is the mark on the right, which is a mark in Korea. Now, does it have the same words? No. Does it have the same picture? No. Is there a chance that this mark is confusing or it can be mistaken? Absolutely. So this is a case in which Starbucks has and will or has pursued this other company for infringement. Moving forward. Now, this is an interesting case. This is the Sam Buck's Coffee business. Sam's name was Buck. She went by Sam Buck. She opened the coffee house, and it had been in her family for years. And she applied for, or excuse me, she used this as her logo moving forward. As you can see, the mark is not similar. The words are not similar, but is there a chance that it can cause confusion? Yes. So this matter was pursued. There is a link to the story. And one of the things that you have to do when you're filing for your mark is to do your research beforehand to determine whether or not there's a possibility that your mark could be considered confusing, that it could be considered similar. And unfortunately, what happens is a lot of times people skip that research phase, spend the money, print their logo. As you can see, they had it on their store, on their brochures. This is how they trademark their brand. And then they get involved in litigation with Starbucks and eventually had to change their logo. So just imagine how much money was spent in litigation, in marketing materials, and that could have been avoided if they would have done their research prior to pursuing the Sam Buck's Coffee. So, question I usually get, do I need a trademark attorney? So, as I showed you on the USPTO site, you can research your own trademarks. You can file your own trademarks. However, working with a trademark attorney helps with a lot of that pre-planning work, including doing that research. Oftentimes we run what's called a comprehensive report for you, which will pull up your mark and other marks that could be considered confusing or similar. We'll also have a chance to find out if people who own those other marks, are they highly litigious? So these are the benefits of using a trademark attorney, and I would highly suggest you do so going forward. A trademark attorney will tell you, they will give you an opinion, in opinion letter, which says or warns whether or not we think that you should pursue the mark. At the end of the day, the choice is yours, but it is worth you spending the money on the front end to complete your research as opposed to having to go through litigation on the back end. Next slide. So the trademark attorney fee, there is a filing fee. There are two. One is $225 per class and one is $275 per class. So what is the difference? At $225 per class, your application is very strict. So that is you applying for your mark in your class, i.e. apparel class 25. If you pay the $275, you have a little bit more wiggle room with your application, and you can tailor that application that's best suited for your business. Now, the filing fees only apply for one class. So if you're applying for apparel and you're also applying for umbrellas and you're also applying for candles, those are all separate classes and you would have a filing fee per each class. So moving forward, we can skip past that because I know that we are strapped for time. So we're moving on to copyrights. What is a copyright? Next slide. As I said before, copyright is a form of intellectual property that it protects the original work of the author. So this includes literature, music, art in written form, movies, scripts, songs, computer software, and architecture. What the copyright does not protect are facts, ideas, systems, and methods of operations. So for instance, if you have an idea for a movie and you tell someone and they take that idea, your idea has not been reduced to written form, you do not have a script, it is not protected by copyright. Moving forward, when you create that idea into written or tangible form, you are the owner of the copyright. You can use the copyright symbol. However, if you want to have additional protection in the federal courts, if there is an issue with infringement, you want to file your copyright with the Copyright Office. Next slide. So here is a graph of different works that can be copywritten on the left and that cannot be copywritten on the right. Moving forward. There are different types of copyright registration. Sometimes if you are the sole author of the work and nobody else helped you and you created that literary work, you will file a single application. However, there are times where you work with other people when it's a collaborative effort and you can apply for an application that includes all of the authors. Also, if you, excuse me, I just saw the question. Also, if you have a group of work, they can be copywritten together. I'm sorry, guys. I just looked at the chat. I'm going to get to your questions at the end. It just distracted me a little bit. Sorry about that. Moving forward. One thing I wanted to let you guys know is that this year there has been a new type of registration for short online literary works. This literally just came out about September. So this is for works that you have reduced to writing online. The literary work contains between 50 and 17,500 words, and it was first published on your website. So these are for those blogs. These are for your blog posts. And so this allows you to group a number of your posts on your blog on one application, as opposed to having to get a copyright for each individual blog post. So this is very important as we move forward in this digital world. Next slide. Okay, copyright infringement. So if you're wondering whether or not you're infringing upon somebody's copyright, there are a few things that you have to understand and ask yourself. Number one, if you did not create that body of work, if you did not create that picture, if you did not write that text, it does not belong to you if you're getting it from somebody else. So if you have created that body of work, the way you protect yourself is through registration. Moving forward. So this comes into play every day because there's social media sites like Facebook, Twitter, Pinterest, in which we all share, we share articles, we share pictures. And how does this come into play with copyrights? Well, all of these platforms have a term of service and they allow and promote sharing. However, what you need to do is to protect yourself if you're sharing that information, especially if you're sharing it in a commercial way. Moving forward. So In 1998, they enacted the Digital Millennium Copyright Act. And this essentially allows for a person who feels as if their copywritten work has been infringed upon to contact the site, and they ask that a notice be sent into a notice is sent to the purported infringer, asking them to take down that information. A lot of times this happens very innocently. Like I said, social media promotes sharing. However, this is an area that you really have to be careful, especially if you're using that work in a commercial way. Moving forward. Okay, so how do you avoid copyright infringement? Um, First, you get permission to publish the copyright owner's work. So the screen that is shown to you is a site that I go to. It's called Plagiarism Now. And if you notice at the very bottom, there is a form, and it asks, do you want to republish this article? Request permission here. It is free. When I want to use their information, their articles from their site, I fill out this form. They let me know whether or not it's okay for me to republish that on my website. If you see another person's blog, what you should do, and you want to republish that blog on your site, you should reach out to the author of that blog or the publication and seek permission to do so before publishing on your site. And again, this is a gray area when it comes to publishing or resharing on a social media site versus your own blog site. You don't want to hold it out as if you are the owner. And sometimes attribution, meaning just, citing the owner or the author, is not enough. Also, you can obtain a license to publish certain works. So one thing, again, in this social media world, something that a lot of us do, we'll just go on Google and grab a picture and use that picture. You don't want to do that. Again, that picture does not belong to you. However, there are a lot of pictures on the internet that are covered by licensing and are covered by Creative Commons, which gives people the license or the right to republish work with certain conditions, such as attribution. Attribution may be, they may say you can use this photo, but you have to attribute the original photographer. So moving on. Let's see. All right. And lastly, the best way to not infringe upon somebody else's work is to create your own content. Now, another area in which this comes into play are works for hire. So for instance, if you have hired somebody to write for you, in a trademark sense, if you've hired somebody to create a logo for you, although you have hired those people, and although under works for hire, because you hired somebody to do that work for you, it should belong to you. What you should also do is cover yourself and get a trademark transfer agreement or a copyright transfer agreement, making sure that you are the owner of that work. Moving forward on the slides. Okay, what is a patent? Patents are for inventions. Patents give a limited duration to have that patent and to have this and have the protection of the patent. There are three types of patents. First is a utility patent, and this is the patent that most people think of. You have created something, moving on to the next slide, you have created something, it is new, it is innovative, nobody has done it before, or you have improved upon something. So you can file for a patent for that, and that patent is good for 20 years from the date of filing. Next slide. The second main patent is a design patent. So this covers the visual characteristics of that work. One of the most famous design patents moving forward was one of the original Coca-Cola bottles. So in the 1900s, there was actually a contest to design a Coca-Cola bottle, and a certain company won. But and then Coca-Cola designed their own bottle and received a patent for that bottle. And as you can see, that is a very iconic Coca-Cola bottle. We all will look at that and know that that is the original bottle. And eventually, after getting the patent for the Coca-Cola bottle, they also went ahead and got the trademark moving forward. And there is a plant patent. So just to make light, and I know some of us have taken on gardening during the pandemic. And if you have been out there in your garden and you've created some type of new flower that has never existed before, you can apply for a patent for that flower or for that plant moving forward. The patent registration process is complex and it is long. So just like with copyrights and trademarks, people ask, do I need an attorney for this? And it's highly suggested that you do get a patent attorney. I am not a patent attorney. I focus mainly on trademarks and copyrights, and that is because the patent process is complex, and they actually have an entirely separate bar that attorneys can take to become a patent attorney. Moving forward. So the simplified steps for obtaining a patent is doing your research, making sure that your what you want to patent has not been used before, that it has a use, that it is novel, and that it's something that's new, but it can also be non-obvious. You choose the type of protection that you want. So you determine whether or not this is something that should be trademarked or something that should be patented. You draft your patent application, again, hopefully with the help of an attorney. You file your application and wait for a formal response. Again, this is the oversimplified steps to obtaining a patent. Next slide. So if you're at the beginning of your patent process, one of the things about the patent is it is good from the date of filing. However, if you are not there yet, you can apply for a provisional patent application. So there is no provisional patent there's no provisional patent itself, but you have the application, which you can file before you have done everything that you need to do in order to apply for the patent. And by applying for the provisional patent application, it reserves that right to have the patent protection go back to the first date of that filing. So for instance, if you are working on a potential patent and there may be a competitor out there that you know of that is working on something similar, it would behoove you to provide, to apply for the provisional patent to reserve your date of filing moving forward. Okay, so I know that I've run over time, but what I wanted to do is not just preach to you or educate you. I wanted to give you some practical, a practical application of your knowledge. So everybody has some type of intellectual property in their inventory. And I have a list of things that could be used to, for you to build up your intellectual property inventory. So you want to look at your blogs, your books, your courses, your email templates. Have you indicated that they belong to you via a copyright symbol or via a trademark symbol? And one thing that I skipped over before is when you create a mark, when you use a name, when you use a brand, you can use the TM symbol, indicating that this is your trademark property. However, it is not a registered trademark until you go through the registration process and are granted the trademark, and then you can use the circle R. But moving forward through your inventory, do you have poems? Do you have songs that you have written? Do you have designs that you have created? Recipes themselves they cannot be copywritten because they are very common, but have you put together a blog post or a story around your recipe? Do you have worksheets that you provide to your students? Do you have curriculums that you provide to your students? Next slide. Customer-driven content. If you work with customers, you've written scripts for them, again, provided worksheets, step-by-step guides, infographics, all of these materials are your intellectual property moving forward. Operations context. So are you in business and written a strategic plan or a business plan for a business? Do you create training materials for your team? All of this information is intellectual property moving forward. And lastly, product, services, and assets. And I think we've gone over templates before, but they also include formulas, blueprints, designs, keynote addresses, and presentations moving forward. And so I have tried to condense an overview of intellectual property in the 30 plus minutes that we have been on here. And I just want to say thank you to everybody that has appeared. I did notice that there are some questions in the comments, and I am going to swing this back to the Innovation Center so I can take a look at the chat and see if I can answer some of your questions.
Great. Corinne, if you'd like, we can read them out to you. We can kind of facilitate the question process. So you just kind of have to answer. Okay, great. So I'm going to let Tiffany do that. That's usually kind of how she facilitates. So Tiffany, if you could pull back up and we'll get into these questions.
Okay. So the first question is, should you copyright your blog site title?
So your blog site title is essentially the brand of your blog. So you should file for a trademark for the title.
Okay. And then the next question is, what is the significance of the year listed after the copyright symbol? How do you properly use it?
So the year listed indicates when it was produced, and a copyright is good for, I believe it is, oh my goodness, it's at the tip of my tongue. It is 70 years, your life plus 70 years.
Okay, and then the next question is, I have a chart that I use to train my clients with, and that's my original unique work. I'm fearful to put it out publicly because I don't want someone else to take the design of this chart and use it as their own. Is there something I need to copyright it or trademark it?
Yes, you would obtain a copyright for your chart.
I did not expect these answers to be so concise. Sorry. 1 second. Let's see. All right. The next question is, if you've been granted a patent and you invent another product from that patent, do you need to apply for another patent? And if not, does the limitations for the first patent end with the new product?
So for that, I am going to say that you would have to refer to a patent attorney. Again, I just wanted to give you an overview of patents, but that is not my area. So I apologize.
That's actually all of the questions that we have so far.
Okay, great.
So Corinne, since we have a couple of minutes left, can you talk about maybe some of the common pitfalls? I know one of the things that you and I worked on together was my big trademark mistake, right? Which was filing on my own and not knowing what the landscape was. And thankfully you helped me to navigate that space and to try to resolve that. But what are some of the common pitfalls that people run into with intellectual property?
Okay, a common pitfall is not doing your research before applying and not doing extensive research. So for instance, you can research on your own. You can go to Google and see if there's anything that's out there that's similar to what you have done. But again, when you work with an attorney, they will do a comprehensive report for you. And in that comprehensive report, as I showed you with the Starbucks model, there might be a brand, a trademark out there that could be similar to yours, but you might look at it on your own and say, oh, well, mine is different. I should be able to get that trademark for that. But that doesn't mean that somebody is not going to say that you're infringing upon their brand. So I have a client now who they use the same word in their trademark. And they are in the same class. However, one class is fashion and the other class is education. So the issue that we have here is anybody that is looking for this brand in the fashion industry going to confuse that clothing, that stylish clothing, with school t-shirts for seventh graders. So there are some people that may have looked at that and said, you know what, they're both the same word, they are in the same class, I'm going to leave it alone. But there are other people that will say, no, I'm going to go ahead and fight this. And this is a battle that we're going through right now. And when I say battle, I say that lightly because like I said, I come from a litigation background. And even though some of these trademark, copyright, and patent matters do end up in litigation, oftentimes people do try to work things out beforehand and come to an agreeable solution, because who really wants to spend all the money and the time and the years going through litigation? Let me think, other pitfalls or battles. Trying to think of some, so this might be, it might be plain on its face, but to me it's not. I told you that I sell apparel. So I sell on different websites such as Etsy and Amazon, and there are plenty of Facebook groups out there. So yesterday there was one young lady in our Facebook group and said, oh my God, Etsy shut down my listings, and these are my best sellers. Well, what she had were apparel with the LV on there for Louis Vuitton. She had a tumbler with Louis Vuitton around it and the symbol for Starbucks. So of course, these are highly protected. They are highly protected brands. They're highly protected trademarks. And quite frankly, she was lucky that Etsy just shut down that actual listing and not the entire store. There are some people that are more litigious than others. And it's my understanding that Louis Vuitton is quite litigious. I told you guys in the beginning that one of my favorite things is Baby Yoda. So I told you that because there's a very interesting story behind that. Baby Yoda is a part of the Star Wars brand. The actual name of Baby Yoda is not Baby Yoda. He was called the Child.
Oh.
And in an effort to surprise the public, the companies did not trademark. They did not create any apparel. They did not create any anything else having to do with the Mandalorian series before it was released. They knew that Baby Yoda was going to be a hit, which is one of the reasons why they held it back. But what happened was Baby Yoda exploded all over the place. Everybody was making T-shirts and cups, and obviously Lucasfilms and Disney, they are fighting this right now, but they did not go ahead and file for their trademarks for this image. And in fact, I noticed that somebody filed a trademark for Baby Yoda in January. That has nothing to do with the company. They're definitely going to fight this. I could see them coming to a compromise, but this was a major a major oversight on behalf of Lucasfilms and Disney. Another issue that's out there in the public now is the Redskins, who are no longer called the Redskins. They're called the Washington Team. And there have been a number of potential names that have been thrown out there for the Redskins. Well, some of the names that they're interested in, their trademarks are owned by other people. I told you guys that trademarks are an asset. And so one of the things that can happen is people are like, oh, well, they're not going to be able to get that. That's already trademarked. Well, the person who owns that trademark can sell it to the Redskins if they really want it that bad. When you hold these intellectual property registrations, your copyright registration, your trademark registration, your patent, you can sell it You can keep it, you can bequeath it, you can hand it down through your family, you can license it. So this is one of the reasons why entrepreneurs absolutely need to have registrations on their valuable assets, because these are ways for you to make money and for you to grow.
Awesome. Thank you. I think we have a couple more questions.
Yeah.
Okay.
Let's see. So one question is, would I have to pay 2 trademark fees for the logo and colors?
So it depends. I'm sorry, it's a very attorney answer. Let's say your logo is red, white, and blue, and you want to trademark your red, white, and blue colors. That is 1 trademark fee per 1 class. However, if you wanted your logo in 2 separate colors, like one's red, white, and blue, it's the same logo, but the next one is green, purple, and yellow. Yes, those would be 2 separate trademark fees.
Okay, and the next question is, would you recommend getting an intellectual patent even if you have a patent and you want to sell overseas? Oh, I'm sorry, an international patent.
International patent. I would say yes, but again, this is an area where you would definitely want to consult with a patent attorney, especially because it's dealing with international intellectual property.
Corinne, is there ever a time when copyrights and trademarks overlap? Like where you have some sort of product where you may feel like you need both protections, or do products or ideas tend to only fall into one category?
Oh no, they can overlap quite frequently. So for instance, going back to Star Wars, Lucasfilms or Disney, whoever owned Star Wars at the time, would get a copyright for the actual script for the film, but then get a trademark for the Star Wars brand.
Mm-hmm. Okay, that makes good sense. Very good. So if anybody else has any questions, please feel free to drop them into the chat. I guess I'll share a little bit about my story. I know I alluded to it earlier, but I was one of those people. I filed on my own, and now I have been healed from do-it-yourself when it comes to trademarks and patents. I thought I could do it myself. I filed for a trademark for a brand that I had started using, printing. I had started, doing events on this brand, decided I was this is easy enough. I'm the only one with this. It's, my brainchild. I'm going to file. And at the very last minute, I got an opposition from a company who didn't want me to use my brand at all. They said it infringed. And even though I thought my brand was very different from theirs, even it was a design mark. It wasn't even a word mark. It's very different. We went into kind of this back and forth. So we can kind of talk about some of the ways. I don't mind kind of being the guinea pig. We can talk about some of the ways I went wrong, right? So the first thing I did wrong was not talking to an attorney, right? That was really the first thing that that went wrong, that kept me from filing properly and to even know who I was filing against, right, Corinne?
Right. And what happens, I talked about this in the presentation, is a trademark attorney will do a search for you. And in that search, not only do they come up with other brands or trademarks that may be similar, it will show who the owners are, and they will also show how litigious these owners are. So the company that opposed Dr. Alexander's brand, they are quite litigious. They own a number of marks, and they are on top of things. They have somebody that just monitors their marks, and anything that they think that comes close to their brand, they are going to oppose. So that's one of the things that an attorney will help you with. For instance, there are some companies out there that perhaps they have a trademark and they haven't used it in years, and they haven't filed any oppositions. An attorney might tell you, you know what, go ahead. You might have a very strong chance of getting that mark, but that is the important research that should be done before filing.
Absolutely. Absolutely. So that was my first mistake. And then I kind of sat on it because I didn't know what to do when it was time to respond. When I got the letters and all this, when they started sending cease and desist letters, and I didn't know what to do. So, that's when I really started, looking at, I need legal help to get this resolved. And so it never went to court. It hasn't gone to court. We really have been negotiating, but it is really an intense process because you're trying to keep your brainchild, you're trying to keep your intellectual property, but you really are at the behest of whatever the existing trademark holder says, right? Because they're the one with all the rights. They've gotten their trademark and they can really defend it. And you have to decide whether or not you want to go into that intense legal battle. And in our case, I think this group is pretty large. They've got way more money, way more attorneys. And so we've just decided to kind of negotiate our way out of that. But, can you kind of talk about maybe some of what can happen? And I know you alluded to it in your presentation before, but can you talk a little bit about if one of us finds ourselves in a trademark or patent or copyright issue, what steps should we take? What can we expect? What do we do?
Okay. So like I said, usually you will get an informal letter first. Let me not say usually. Sometimes you will get an informal letter that will say, hey, you posted this or you're advertising this. We feel like it infringes upon your trademark, our trademark. Can you take it down? I can tell you that I've gotten one of those letters. When I first started blogging, I posted something from another blog. Again, I gave them all the credit, but they said, no, you did not ask for permission. Can you take it down? And I did. The next step is a cease and desist. And when you get a cease and desist order, that's when things are starting to get serious. And then the next step is a filing. So backing up a little bit, in the trademark process, after you have filed for your trademark, sometimes there is a back and forth with the trademark office as to things that they think that you should do to change your application in order for your application to go through. These are things called office actions. And oftentimes you do need an attorney to help you with those as well. When you've gotten through that process at the trademark office, what they do is they publish your mark for opposition. So that was the process that Dr. Alexandra was in. She went through the trademark office. She had no problems with the trademark office, ready to go. Once they say that you're published for opposition, somebody has 30 days in which to oppose your mark. And that's what happened. So you think everything is all free and clear, but that is what happened. But that is what you can do if you feel like somebody has imposed upon your mark as well. So it goes back and forth because you want to protect yourself. You want to protect your own branding, your own marks, but other people want to do the same. I'm trying to think. I kind of went off track. Dr. Alexander, was there anything else that you asked me in that question?
No, I think that's good. I think it's just, good for people to know, what they can expect once they file. For me, I was excited. I think I was down to like day 28 out of 30. And I was just waiting for day 30. And I was so excited that I was going to get my brand trademarked. And like at the last minute, I got a notice that my trademark application was being challenged. And so I had no idea what to expect. And so having your expertise, really was helpful. And I think for those of us who are, entrepreneurs, that's what we do, right? We're do-it-yourselfers. We figure if you give me instructions, you give me a tutorial, and you give me the tool to do it, I can figure it out. That's, that's what we do. And there are some of these processes that we don't realize that you really can get yourself in the hot water doing it yourself. And this is one of those areas. And it was a really, really important lesson for me to discover that not every do-it-yourself process really is smart to do yourself. So I just really wanted to thank you, Corinne. We've got one other question really quick. We have time. I'm interested in music. I like to post music online. How can I go about doing this legally? And how do I obtain the correct licenses to do this?
Okay.
I had a similar question along the same lines because I'm a
Okay.
music, I write music. And so, again, my question is along the same lines. How do I protect my song lyrics that are like original from me? I've heard about like mailing them to myself, but I didn't know if that was like
no. Yeah, they call that the common law man way of getting legal protection. Like I said, from the moment that you put pen to paper or note to paper, it belongs to you, but you need to register it. And the thing is, especially with copyrights, there's a very low barrier to entry. So if you are the one person that has worked on this one song and you've reduced your lyrics, you can file for that copyright registration for $35 and do that for every single one of your songs. You know, and then what you do want to do is get affiliated with, I believe it's either BMI or ASCAP, and you want to start a relationship with them and file with them. And then going beyond that, I would say to talk to an entertainment attorney as to where you should go further. Because for instance, if you create your own music and then you've uploaded it to Spotify or to SoundCloud, you have to look at the terms of service because you're putting it up there because you want people to hear your music, right? But you have to see how much of that do you own and how much of that are you giving away if you do not have the proper registrations. That makes sense. So first step for you is to file your copyrights for your music. Next step, entertainment attorney.
Okay, awesome. Dr. Rhonda, did you have anything else?
I don't. I just want to thank everybody for coming. I want to thank Attorney Coger. Thank you so much for sharing with us this morning. It has been absolutely informative. I've really enjoyed it. And I hope you have too. We have put our survey in the chat. If you enjoyed this, this event, please fill out the survey. It helps us to know what you need, what you want to see more of. And it helps us to continue to bring that kind of content to you. So please just take like 2 minutes, click the link, fill out the survey, and give us a little feedback so we can continue bringing you content like this. Again, thank you, Attorney Coger, for joining us. Thanks to everybody. I hope you have an amazing day, and we will see you next time. Thanks so much.
Bye-bye.
Thank you,
everyone.
Thank you.